Good morning, everybody. Good morning, everybody. Welcome to Law Minds. Today, we'll be starting with the topic General Exceptions, and it is given in Chapter 4 of IPC. So, let's begin. So, here I've mentioned this is Section 76. So, it says, act done by a person bound or by mistake of fact, believing himself bound by law. Nothing is an offense which is done by a person who is or who by reason of mistake of fact and not by reason of a mistake of law in good faith believes himself to be bound by law to do it. Now all this you might be confused about it, so let's understand it with the help of an example. So okay, so A is a soldier and he fires on a mob, but it is by the order of his superior officer in conformity with the commands of the law. Then A has committed no offense. Okay. Let's take another example. So, is an officer of a court of justice being ordered by that court to arrest Y, and after due inquiry, believing Z to be Y, arrests Z. A has committed no offense. So, this section basically offers an exception for people who perpetrate a criminal act because they think they are lawfully obliged to do, right? Like in this also, he was ordered by the court, right? And he's an officer of a court of justice, and he misunderstood Z to be Y. Okay. Now, and in here also, this army officer, the soldier, is commanded by his superior army officer. Okay, he doesn't do it because he feels like doing it, right? So this section protects these people, right? Because this is an exception. Okay, so this exception applies to police officers, public authorities, and people who behave in good faith because they think it is their lawful obligation to do so. Okay, so that's it for this section. Now let's go to another section. This is section 77. Let's read what it says. So, act of judge when acting judicially. Nothing is an offense which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law. Okay, so okay, now this exception uh, acknowledges that judges have a responsibility, right, to carry out their responsibilities impartially and without fear of favor. Okay, now let's understand it with the help of an example. So, if a judge sends somebody to prison for a crime they were found guilty of, but later on some evidence emerged and they realized that no, this person is not guilty of this thing, then the judge may not be held legally responsible for the damage done to the innocent person. Okay, because the judge behaved within the purview of their judicial power, right? The judge, whatever sentence, whatever punishment the judge gave, it was in accordance with the law, right? So you cannot hold the judge responsible that now I am innocent, so now it is your fault. Why did you send me to jail or whatever punishment you have been given? Okay. Now let's go to section 78. So section 78 says, act done pursuant to the judgment or order of court. Nothing which is done in pursuance of or which is warranted by the judgment or order of a court of justice, if done whilst such judgment or order remains in force, is an offense, notwithstanding the court may have had no jurisdiction to pass such judgment or order provided the person doing the act in good faith believes that the court had such jurisdiction. Let me correct a slight mistake here. Right, perfect. Okay, so yes, so now this is also a lot of legal jargon, so let's understand it in simpler words. So this means that if a person is acting in accordance with a judicial order and lacks the power to challenge the legality of that order, they may be able to use this section as an exception. Okay, so for example, if a judge orders a police officer to remove somebody from their property, then the officer is lawfully compelled to carry out the removal. Okay, now let's go to section 79. So let's read it. Act done by a person justified or by mistake of law believing himself justified by law. Nothing is an offense which is done by any person who is justified by law or who, by reason of mistake of fact and not by reason of mistake of law, in good faith, believes himself to be justified by law in doing it. Okay, so don't be confused. Here we have an illustration which says that so now A sees Z commit what appears to A to be a murder. So according to A, it is a murder. Now A, in the exercise to the best of his judgment, exerted in good faith. One second. Yeah. Exerted in good faith of the power which the law gives to all persons of apprehending murderers in the fact seizes in order to bring Z before the proper authorities. A has committed no offense, though it may turn out that Z was acting in self-defense. Okay, so according to this section, which is section 79, so in this section, it is basically said that if I do something, an act that is justified or by mistake of fact, I don't know the exact situation, but prima facie or whatever I could understand to the best of my judgment, and it should be in good faith, right? Here also, this good faith is extremely important. Okay, and even here, A in good faith he believed that Z has committed the murder. Okay, and it is not that A had some enmity with Z, right? So that's why, okay, in good faith. So in good faith is extremely important. Then I can plead that under section 79 of IPC, then it comes as a general exception. Okay, so that is a general exception. Now we'll talk about section 80. What does it say? Let's read it. Now, accident in doing a lawful act. Okay, so nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge, in the doing of a lawful act in a lawful manner by lawful means with proper care and caution. Okay, now we'll understand it with the help of an example. So A is at work with the hatchet and the head flies off and kills a man who is standing by. Now, if there was no want of proper caution on the part of A, his act is excusable and not an offense. Okay. Now, so by this example, so it is that A is at work with a hatchet. Now, it is not illegal, right? That is a lawful work that he is doing. Now the head flies. So now, if A can establish that I was not doing anything unlawful, it was by pure accident, right? What we saw here, and it was without any criminal intention or knowledge. I did not know that the head will fly off. I did not know. Okay, and yes, so as I said, it was a lawful act. Doing his work with a hatchet, not unlawful. I was doing it in a lawful manner. I was not, carelessly doing my work. Okay, so and by lawful means with proper care and caution. So if A is able to establish all these elements, then A is not liable. Okay, now let's move on to section 81. So let's read what it says. So act likely to cause harm but done without criminal intent and to prevent other harm. Now what it says, that nothing here. Okay, so it says nothing is an offense merely by reason of it being done with the knowledge that it is likely to cause harm, if it is done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm or property. Now, to person or property. Okay, so let's read the explanation. So it is a question of fact in such a case whether the harm to be prevented or avoided was of such a nature and so imminent as to justify or excuse the risk of doing the act with the knowledge that it will likely to cause harm. So obviously everybody's confused, so don't worry, we'll move on to the illustration, our savior. Okay, so let's read the illustration. So A, the captain of a steam vessel, suddenly and without any fault of or negligence on his part, finds himself in such a position that before he can stop his vessel, he must inevitably run down a boat B with 20 or 30 passengers on board, unless he changes the course of his vessel, and that by changing the course, he must incur risk of running down a boat C with only 2 passengers on board, which he may possibly clear. Here, if A alters his course without any intention to run down the boat C and in good faith for the purpose of avoiding the danger to the passengers in the boat B, he is not guilty, right? As we read in the section above, then he would not be guilty, though he may run down the boat C by doing an act which he knew was likely to cause the effect, if it be found as a matter of fact that the danger which he intended to avoid was such as to excuse him in incurring the risk of running down C. Okay. Now another example. A is in a great fire pulls down houses in order to prevent the conflagration from spreading. He does this in good faith of saving human life or property. Here, if it be found that the harm to be prevented was of such imminent nature as to excuse A's act, A is not guilty of the offense, right? So A did it in good faith. Now, this is a very important point. Even in the military, the boat example earlier, the person, the captain, the officer did not have any other option, right? So that person had to hit boat C with 2 passengers. Okay, but we need to understand that it happened in good faith. It was to protect something. Okay, and in that way, a greater harm was prevented. Okay, and in this case also, a greater harm was prevented. That is why uh, A pulls down houses, okay, so that the fire doesn't spread too much, right? So then it is excused, okay, then you're not liable. Okay, now let's begin with the section 82. So it says act of a child under 7 years of age, talks about this thing. Now nothing is an offense which is done by, one second, yeah, which is done by so a child who is under 7 years of age, right? So I don't think we need an illustration for this, so let's take a very simple example. I'm sorry, yeah. So there's this child, whatever, child A did something, maybe let's imagine he, whatever, like any minor act, anything children do, right? So the parents can be held liable in certain cases. It is not conclusive, it is not a conclusive statement. But the child as such is not liable because if the child is under 7 years of age and it is considered that the child is not mature enough to think of its actions. Right, now let's move on to section 83, right? So act of a child above 7 and under 12 years, under 12 of immature understanding, right? So nothing is an offense which is done by a child above 7 years of age and under 12 who has not attained sufficient maturity of understanding to judge the nature, yeah, okay, to judge the nature and consequences of his conduct on that occasion. Okay, so yeah, okay, so this is section 83, right? Now the section 83 says that if a child is above 7 years and under 12 years, then nothing is an offense. So that is nothing is an offense because okay, so we think that the child has not attained sufficient maturity of understanding to judge the nature and consequences. Okay, so let's start because, like, in the opinion of law, a child under the age mentioned is not capable of differentiating between right and wrong. So any intention that is criminal does not arise. Okay, now let's move on to section 84. So it says that it talks about act of a person of unsound mind. So nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. So okay, to give an illustration, this person X did something which is like not lawful, okay, or not lawful, yes, but it was done because this person was of one second, this person was of unsound mind, okay, this person was not capable of understanding what he's doing, okay. So that's why so if you are not able to differentiate that what is right, what is wrong, then how come can you understand that if it is an offense? So yes, so even people of unsound mind are also exempted, but you have to establish it in the court of law. Of course, you're not exempted so easily. Right, now let's talk about section 85. Right, so this section talks about when a person incapable of judgment by reason of intoxication caused against his will. Okay, so this exception says that nothing is an offense which is done by a person who at the time of doing it uh, I'm sorry, yeah, who at the time of doing it is by reason of intoxication, right, incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, right, yeah, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. So this is fairly easy to understand, I feel. Let's take an example. I am Miss X, okay. So I had to go to a friend's birthday party, uh, okay, in the evening. Now, let's say Mr. A administered some, I asked for maybe a certain kind of drink that is non alcoholic, but Mr. A gave me something that is alcoholic in nature, and because of that drink, and I was not able to differentiate, and I drank it. So now, basically, as a result, I am intoxicated. I'm not in my senses. No, I'm not in my senses. I get into a fight. I beat somebody up. I do like something unlawful. So now it is not my fault. Okay, because I did not have that alcoholic drink on according by my wish. Okay, I was administered that. Okay, it was administered to me against my will. I did not have any intention of drinking. I did not even ask for it. So this Mr. A would be, like the court would deal with Mr. A in this matter and not with me, right? So now let's talk about section 86. So now, offense requiring a particular intent or knowledge committed by one who is intoxicated. Now, okay, in cases where an act done is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. So now, according to section, we're talking about 86, right? Yes. So now 86 applies when a particular offense is committed having the knowledge and awareness of the act, even though the person is drunk. So it may happen that I am a habitual drinker. So I am carrying forward the example which I gave in the previous section, that I am a habitual drinker and I am accustomed that certain amount of alcohol will not affect my capability to judge whether what I'm doing is right or wrong. Okay, so it would not judge it, right? So I may still be in my senses if I do something okay, like yeah, so like something was administered to me and I still was in my senses, so I cannot say that just because I was drunk, so this is not my fault. Okay, so I'm accustomed to drink this x ml and I don't lose my senses. So I cannot say that okay, like just because I was under the influence of wine, I just had it, so I can do anything. But yes, there's an exception that I may not lose my senses and all, but if it is administered to me without my knowledge, then I can use this exception. Okay, now let's talk about section 87. So, act not intended are not known to be likely to cause death or grievous hurt done by consent. So, this exception says that nothing which is not intended to cause death or grievous hurt, or which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause, or to be intended by the doer to cause to any person above 18 years of age. Very important to understand this criteria. Remember the criteria. Who has given consent, whether express or implied, to suffer that harm or by reason of any harm which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Now, a lot of legal jargon. Let's move to illustration. Okay. Now, A and Z agree to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which in the course of such fencing may be caused without foul play. And if A, while playing fairly, hurts Z, A commits no offense. Okay. So if they, because it was mutually agreed, okay, consent दिया जा चुका है, it is according to the consent, like nobody is doing it unlawfully, right? There is no foul play. So then if it is by consent, then it is fine. Okay, then nobody has committed any offense. Like you cannot hold your friend liable for maybe like beating you up when you both were playing something, right? And you both gave consent that yes. But again, the thing to be taken care of is that there should be no foul play and there should be consent, and the age criteria that I mentioned here, that it should be above 18 years of age. Okay, now let's move on to the next one. It is section 88. So, act not intended to cause death done by consent, okay, in good faith for a person's benefit. This says that nothing which is not intended to cause death is an offense by reason of any harm which it may cause, or be intended by the doer to cause, or be known by the doer to be likely to cause to any person for whose benefit it is done in good faith, and who has given a consent, whether express or implied, to suffer that harm or to take the risk of that harm. Okay, let's understand with the help of an illustration that A is a surgeon knowing that a particular operation is likely to cause death of Z, who suffers under the painful complaint, but not intending to cause Z's death, and intending in good faith Z's benefit, performs that operation on Z with Z's consent, then A has committed no offense. Okay, so here we see that although he knew that this operation could cause the death of Z, but because it happened was Z's consent and there was good faith, so it is not an offense committed by A. Now let's talk about section 89. 89 says that act done in good faith for benefit of child or insane person by or by consent of guardian. Okay. Now nothing which is done in good faith for the benefit of a person under 12 years of age or of unsound mind by or by consent, either express or implied, of the guardian or other person having lawful charge of that person, is an offense by reason of any harm which it may cause to be intended by the doer to cause, or be known by the doer to be likely to cause to that person, provided first that this exception shall not extend to the intentional causing of death or to the attempting to cause death. Secondly, that this exception shall not extend to the doing of anything which the persons doing it knows to be likely to cause death for any purpose other than the preventing of death or grievous hurt or the curing of any grievous disease or infirmity. Thirdly, that this exception shall not extend to the voluntary causing of grievous hurt or to the attempting to cause yes okay, attempting to cause grievous hurt unless it be the purpose of preventing death or grievous hurt or the curing of any grievous disease or infirmity. Fourthly, shall not extend to the abatement of any offense, to the committing of which offense it would not extend. Okay, so let's move on to illustration to understand this section better. So, A, in good faith for his child's benefit, without his child's consent, has his child cut for the stone by a surgeon, knowing it would be likely that the operation will cause child's death, but not intending to cause death. A is within the exception in as much as his object was the cure of the child. So here it is very easy to understand this. So A is in good faith. Okay, so A is the guardian, or A has the lawful charge of the child. Now, if A has consented to an operation, and so it is basically for the child's well-being, right? So right now it may be dangerous. Right now it may be, that the child can die in the operation, but it was done in good faith. Okay, it was, so the child gets relief from the pain. So then A has not committed an offense, right? Now let's talk about section 90. So consent known to be given under fear or misconception. A consent, so this says that a consent is not such a consent as is intended by any section of this code if the consent is given by a person under fear of injury or a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequences of such fear or misconception. Okay, so let's understand this much. So basically, a consent will not be considered a consent if it is given by a person under fear of injury or a misconception of fact. Okay, now let's talk about consent of insane person. So if the consent is given by a person who from unsound intoxic okay, so who from it is actually unsoundness of mind or intoxication. So okay, let me write it. Unsoundness of mind or intoxication is unable to understand the nature and consequences of that to which he gives his consent. Okay. Now, consent of child, unless the contrary appears from the context. If the consent is given by a person who is under 12 years of age, then it will be considered as a consent of child. Okay. Now, let's talk about section 91, exclusion of acts which are offences independently of harm caused. The exception in section 87, 88 and 89 do not extend to acts which are offences independently of any harm which they may cause or be intended to cause or be known to be likely to cause to the person giving the consent on whose behalf the consent is given. Now, illustration. Well, let's understand it with the help of an illustration. Now, causing miscarriage, unless caused in good faith for the purpose of saving the life of a woman, is an offense, independently of any harm which it may cause or be intended to cause to the women. Okay? Therefore, it is not an offense by reason of such harm, and the consent of the woman or her guardian to the causing of such miscarriage does not justify the act. Okay, so now in this, let's understand it, that if a doctor causes a miscarriage, so if it is done for the well-being of the women, then it is fine, it is not an offense. But if it is done, if there is no such thing, if, like, we know that it is very prevalent in like rural areas, people do this process of amniocentesis. So it is basically like knowing the gender of the child. Now when they find out that it is a girl, then they abort it, right? So when they abort it, then the girl child, so it is an offense. Okay, it is an offense under the Indian law, because now it does not matter that any harm which may cause or be intended to cause to the women. So okay, so it is not an offense by reason of such harm. right? So it is, if even if the woman gives consent that yes, miscarry the baby, then also it will be an offense. Okay, now let's move on to section 92. So act done in good faith for benefits of a person without consent. So nothing is an offense by reason of any harm which it may cause to a person for whose benefit it is done in good faith, even without that person's consent, if the circumstances are such that it is impossible for that person to signify consent, or if that person is incapable of giving consent and has no guardian or other person in lawful charge of him for whom it is impossible to obtain consent in time for the thing to be done with benefit provided. Okay, so we have, yeah, firstly, that this exception shall not extend to the intentional causing of death or attempting to cause death. Secondly, that this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death or any purpose other than the preventing of death or grievous hurt, or the curing of any grievous disease or infirmity. Thirdly, that this exception shall not extend to the voluntary causing of hurt or to the attempting to cause hurt for any purpose other than preventing death or hurt. Fourthly, that the exception shall not extend to the abatement of any offense to the committing of which offense it would not extend. Okay. So now this section basically says that it says that it provides for a situation of emergency where there is time to obtain the consent either of the person affected or of his guardian. And the law therefore says that if the act causing harm or likely to cause harm is done for the benefit of the person, okay, concerned and done in good faith, so it should be for the benefit and in good faith, then it is not an offense. So let's see certain illustrations given. Now Z is thrown from his horse and is insensible, not in his senses. A surgeon finds that Z requires to be trepanned. A, not intending Z's death, but in good faith for Z's benefit, performs the trepan before Z recovers his power of judgment for himself. A has committed no offense. So, okay, so now the surgeon did whatever he did. The surgeon took A for treatment. Okay, all right. So, yes, so because the surgeon did it in good faith and for the welfare of Z, then we can say that consent of Z is not like that important here. I mean, it is important, but in this case, because Z was not capable of giving the consent, then it's fine. A has committed no offense. Now to offense of. Okay, so I'll state the illustration. It is actually I missed out certain points. So Z is carried off by a tiger, and A fires at the tiger, knowing it to be likely that the shot may kill Z, but not intending to kill Z, and in good faith, intending Z's benefit. A's ball gives Z a mortal wound. A has committed no offense. Okay, so now in this case, we see that A is a person and Z is taken off by a tiger. So now A, in order to protect Z, fires at Z. Okay, so it is in order to protect Z, right? A knows that it might kill Z or it might cause an injury, but it is to protect him from the tiger because the tiger would kill him anyway. So then A has committed no offense even if Z is injured in the act. Now let's talk about another illustration. So a surgeon sees his child suffer an accident which is likely to prove fatal unless an operation be immediately performed. There is no time to apply to the child's guardian. Okay, no time to apply to the child's guardian. A performs the operation in spite of the entities of the child, intending in good faith the child's benefit. A has committed no offense. Okay, so because A did it in good faith and there was no time and it was the reason why A could not uh, take consent of the guardian was genuine. Okay, then A is not liable. So A is now the next illustration says that A is in a house which is on fire with Z, a child. People below hold out a blanket. A drops the child from the house. Okay, from the house. Okay. House top. Knowing it to be likely that the fall may kill the child. Okay. May kill the child, but not intending to kill the child, and intending in good faith the child's benefit. Here, even if the child is killed by the fall, he has committed no offense. Okay, so mere pecuniary benefit is not benefit within the meaning of section 88, 89, and 92. Now let's talk about section 93, right? Communication made in good faith. So now no communication made in good faith is an offense by reason of any harm to the person to whom it is made, if it is made for the benefit of that person. Okay. Now let's understand it with the help of an illustration. Now A is a surgeon in good faith communicates to a patient his opinion that he cannot live. Okay. Patient dies in consequence of the shock. He has committed no offense. Okay. So it is in good faith. Okay. The surgeon told them in good faith. So then it is not an offense. Okay. Communication in good faith. Right. So A did not intend to cause the death, but this thing had to be communicated, right? So though he knew that it is likely that the communication might cause the patient's death, but yes, A did not intend to cause death. Now section 94, the act to which a person is compelled by threats. So except murder and offences against the state punishable with death, nothing is an offence which is done by a person who is compelled to do it by threats which at the time of doing it reasonably cause the apprehension that instant death to the person will otherwise be the consequence, provided the person doing the act did not of his own accord or from a reasonable apprehension of harm to himself short of instant death place himself in the situation by which he became subject to such constraint. Now explanation. So a person who of his own accord or by reason of a threat of being Peter gang of okay, so sorry, being beaten by the gang of dacoits, knowing their character, is not entitled to the benefit of this exception on his having been compelled by the associates to do anything that is an offense by law. Now, another explanation, a person seized by a gang of dacoits and forced by threat of instant thing, which is an offense by law. For example, a smith compelled to take of tools uh, and to force the door of a house for the dacoits to enter and plunder it is entitled to the benefit of this exception. Okay, so to force the door of a house. Okay, so it is basically for the dacoits to enter. So then it is the smith is not liable because obviously you did it under a threat. Okay. Now, section 95. Act causing slight harm. Nothing is an offense by reason that it causes or that it is intended to cause or that is known to be likely to cause any harm, and if that harm is so slight that no person of ordinary sense and temper would complain of such harm. Okay. Okay, so now let's understand it using an example. Right, let's understand using an example. So, okay, so for this section 95 that we're talking about, now imagine a situation where a person A accidentally steps on B's foot in a crowded bus. The contact is minimal and B barely notices it. B does not feel any real pain or discomfort and quickly realizes it was an innocent mistake due to the crowded nature of the bus. In this scenario, A's act of stepping on B's foot would likely not constitute an offense under section 95 of the IPC, okay? Because the harm caused is so slight that a person of ordinary sense and temper would not complain about it. All right. So this was section 95. Now 96, things done in private defense. Nothing is an offense which is done in the exercise of private defense. So, right. So if I do something to protect myself or my property, okay, then it is not an offense. You cannot hold me liable, okay, because I did it in private defense, right? Now, section 97, right of private defense of body or of property. Every person has a right subject to the restrictions contained in section 99 to defend, now first, his own body and the body of any other person against any offense affecting the human body. So I can do it in my defense or somebody else's defense. Secondly, the property, whether movable or immovable, or of himself or of any other person. So now the property also can be mine or somebody else's. It could be movable or it could be immovable. Okay, and against any act which is an offense falling under the definition of theft, robbery, mischief, or criminal trespass, or which is an attempt to commit theft, robbery, mischief, or yes. Okay. Now, section 98. So I hope like this is clear. Okay, so right of private defense, body of property. Okay, so it is not just that I could use private defense just for me. Okay, it could be for yes, for somebody else, for their property also. Now let's talk about section 98. So, right of private defense against the act of a person of unsound mind, etc. So, when an act which would otherwise be a certain offense is not that offense by reason of the youth, the want of maturity for understanding, the soundness of mind, or the intoxication of the person doing that act, or by reason of any misconception on the part of that person, every person has the same right of private defense against the act which he would have if the act were that offense. Okay, so now there are certain illustrations, but before that, let's understand the meaning of the law, the section. So this section means that if a person does something which would usually be a crime but it isn't considered a crime because of certain reasons, while being young, not understanding what they're doing, being okay, so either they are not able to understand what they're doing, or they are mentally ill or drunk or having the wrong idea about something, mistake of fact, then you still have the right to defend yourself against them if they were committing a crime. Okay, now let's take help of certain illustrations. So Z, under the influence of madness, attempts to kill A. Z is guilty of no offense, but if A has the same right of private defense, but A has the same right of private defense which he would have if Z were sane. Okay, so if Z is mad and tries to kill, then it is not then okay, so Z is not guilty because Z suffers from unsoundness of mind. Okay, but A has full right to use the right of private defense which he would have if Z were sane. Now A enters by night a house which he is legally entitled. So this is another illustration. Okay, to enter Z. No, I'm sorry. Yeah, enters a house which he is legally entitled to enter. Now Z, in good faith, taking A for a housebreaker, attacks A. Here Z, by attacking A under this misconception, commits no crime, but A has the same right for self-defense against Z, which he would have if Z were not acting under that misconception. Okay, so it is simple that A goes to the house that he's allowed to go, but Z thinks that no, A is not allowed and he's a burglar. So now if Z attacks him, then Z is not at fault, okay, because it was under the mistake of fact. But A also can use self defense, okay. A also can protect himself, right? Now let's talk about section 99. So acts against which there is no right of self defense. There is no right, so there are certain exceptions. There is no right of self defense against an act which does not reasonably cause the apprehension of death or of grievous hurt if done or attempted to be done by a public servant acting in good faith under color of his office. Though that act may not be strictly justifiable by law, there is no right of private defense against an act which does not reasonably cause the apprehension of death or of grievous hurt, if done or attempted to be done by the direction of the public servant acting in good faith under color of his office. Though the direction may not be strictly justifiable by law, there is no right of private defense in cases in which there is time to have recourse to protection of the public authorities. So, okay. Now, extent to which this right may be exercised. Okay, so the right of private defense in no case extends to the inflicting of more harm than it is necessary to inflict for the purpose of defense. Now explanation 1. A person is not deprived of the right to private defense against an act done or attempted to be done by a public servant as such, unless he knows or has reason to believe that the person doing the act has reason to believe that the person doing the act is such a public servant. Okay. Now explanation 2. A person is not deprived of the right of private defense against an act done or not deprived of the right of private defense against an act done or attempted to be done, okay, by the direction of a public servant, unless he knows or has reason to believe that the person doing the act is doing so by such direction, or unless such person states the authority under which he acts, or he has authority in writing unless he produces such authority if demanded. So, okay, let's understand it in a simplified manner. So, it basically talks about that, yes, so you cannot use self defense to protect yourself against actions by a public servant like a police officer if those actions don't make you fear for your life or serious injury. This applies even if the public servant might be overstepping their legal authority, as long as they are acting with good intentions as part of their job. Similarly, if you cannot use self defense against actions that are directed by a public servant acting with good intentions and within their job role, if the directions might not be completely legal, if you have enough time to ask for help from the police or other authorities, you should do that instead of taking matters into your own hands. Now, what is the limit of self defense? So, when you do use self defense, you should only use as much force as needed to protect yourself, not more than that. Okay, so but you still have the right to self defense against a public servant if you don't know or have no reason to believe that the person you are defending yourself against is a public servant. You also retain the right to self defense against somebody acting on a public servant's orders if you don't know that they are acting on those orders. Okay, so unless they clearly say they are or show you written proof of their orders if you ask for it. Okay, now imagine a situation where a government official who is a tax inspector arrives at a shop to conduct a surprise audit. The shopkeeper, believing the audit to be a ruse of harassment, decides to resist. However, the tax inspector is not threatening the shopkeeper with death or grievous hurt, but is simply performing his duty, albeit in an intrusive manner. In this case, the shopkeeper does not have the right to private defense to physically prevent the tax officer from carrying out the audit. Okay, so it clarifies that there is no right of private defense against acts of public servants done in good faith, even if the act is not strictly lawful, as long as it does not cause a reasonable apprehension of death or grievous hurt. Okay, now let's talk about section 10. Section 100. Now, when the right of private defense of the body extends to causing death. Okay, so the right to private defense of the body extends under the restrictions mentioned in the last preceding section to the voluntary causing of death or of any other harm to the assailant if the offense which occasions the exercise of the right be of any of the descriptions herein after enumerated, namely, first, such an assault as may reasonably cause the apprehension that death will otherwise be the consequence of such assault. Secondly, such an assault as may uh, reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such assault. Thirdly, an assault with the intention of committing rape. Fourthly, an assault with the intention of gratifying unnatural lust. An assault with the intention of kidnapping or abducting. An assault with the intention of wrongfully confining a person under circumstances which may reasonably cause him to apprehend that he will be unable to have such recourse to the public authorities for his release. Seventhly, an act of throwing or administering acid or an attempt to throw or administer acid which may reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such act. Okay, so In this, let's understand it in a simplified manner. The law of India allows you to defend yourself by causing harm or even death to somebody who is in certain serious situations. Okay, so you can cause death in these serious situations, which are all these 7 situations that I mentioned. Okay, now if we take an example, so where a woman, so let's imagine a woman is walking home at night and a man attempts to forcefully drag her into an alley with the intention of committing rape. Fearing for her life, she manages to free herself, for a moment, and in a desperate attempt to prevent the assault, she picks up a rock and strikes the assailant on the head, causing severe injury. So now, in the case, the women's action may be covered under Section 100 of IPC, as she was defending herself against an assault with the intention of committing rape, which is one of the enumerated offense justifying. Okay, so because, and it may be because the person tried to throw acid. Okay, so these things, all these, the list of offenses that I've mentioned. In these cases, you can cause death, in private defense. Right. Now, section 101. When such right extends to causing any harm other than that. Okay. Now, if the offence be not of any of the descriptions enumerated in the last preceding section, the right to private defence of the body does not extend to the voluntary causation or causing of death to the assailant, but does extend under the restrictions mentioned in section 99 of the voluntary causing of the assailant to any harm other than death. Okay, so in a simplified manner, it says that if the type of attack you are facing isn't one of the serious ones listed in the section before this, like an assault that could seriously hurt or kill you, you don't have the right to kill the person attacking you in self defense. However, you are allowed to defend yourself by causing harm to the attacker that isn't deadly, as long as you follow the rules set out in section 99. Now, let's, as an example, so imagine that there's a person, John, walking down the street when suddenly he's attacked by Alex with a stick. Alex intends to hurt but not kill John. So, under this section, John has the right to defend himself. However, since Alex's attack is not life threatening or of the type that could cause grievous harm, John's right to self defense does not include the right to kill Alex. John can only use necessary force to prevent the attack, such as disarming Alex or pushing him away, but he cannot take Alex's life in self defense. Okay, now let's talk about section 102. So, the commencement and continuance of the right of private defense of the body. So, the right of private defense of the body commences as soon as a reasonable apprehension of danger of the body arises from an attempt or threat to commit the offense. Though the offense may not have been committed, and it continues as long as such apprehension of danger to the body continues. Okay, so in a simplified way, let's read it, understand it, that self-defense for personal safety starts as soon as you genuinely feel that you could be harmed because somebody is trying to or threatening to hurt you, even if they haven't actually done anything yet. You can keep defending yourself until you no longer believe you are in danger. Okay, so if you genuinely believe that now, yes, this person can hurt me, then you can go ahead with self-defense. Okay, but it should be a genuine belief. It could not be that somebody called you up and like, I will beat you, and then you think that no, now I have to exercise my self-defense, private defense. Okay, so not in those, but in genuine circumstances. Right, now let's understand section 103. So it says that when the right of private defense of property extends to causing death, private defense of property, okay, under the, one second, yeah. So the right to private defense of property extends under the restrictions mentioned in section 99 to the voluntary causing of death or any other harm to the wrongdoer, right? Causing death or any harm to the wrongdoer. If the offense, okay, yes, if the offense, the committing of which or the attempting to commit which occasions the exercise of right be an offense of any of the descriptions hereinafter enumerated, namely, first is robbery, second is housebreaking by night, third is mischief by committing, yeah, on any building, tent, or vessel which the vessel is used as a human dwelling as a place for custody of property. Fourthly, theft, mischief, or house trespass under such circumstances as any as may reasonably cause apprehension that death or grievous hurt will be consequence if such right of private defense is not exercised. So now there are certain state amendments. Okay, so Karnataka in section 103 in clause thirdly, after the words mischief by fire, the words or any explosive substance shall be inserted. After the words as a human dwelling or the words as a place of worship or shall be inserted. Right. Now after clause fourthly, the following clause shall be inserted, namely mischief by fire or any explosive substance committed on any property used or intended to be used for the purpose of government or any other local authority, statutory body or company owned by or controlled by the government or railway or any other vehicle used or adapted to the or to be used for the carriage of passengers for hire or reward. Right. So yeah, so let's understand the simplified law. So this says that the IPC allows you to defend your property with force, including causing death or injury to a person who is committing certain serious crimes against your property. However, this is only acceptable under certain conditions as outlined in section 99 of the code. The types of crimes where you are allowed to defend your property in this way include robbery, housebreaking by night, mischief by fire, theft, mischief, or house trespass. Additionally, Karnataka, which is a state of India, has made some changes. So, in cases of mischief by fire, okay, you can also defend your property if the mischief involves explosive substances, and places of worship are also included as places where you can use force to defend against mischief by fire. A new point has been added that allows you to defend property used for government purposes. Local authorities, statutory bodies, government controlled companies, railways, and passenger vehicles to for hire against mischief by fire or explosive substances. Now, explanation using example. Imagine a homeowner. Okay, so we'll explain. Okay, so this is an example. Now you can imagine that a homeowner who is like Mr. Sharma or like Mr. X, who lives in a quiet neighborhood. One night he is awakened by the sound of glass breaking. Okay, now peering out of his bedroom window, he sees an intruder with a crowbar breaking into his shed, where he stores expensive tools and equipment. Now, fearing that the intruder might attack him or his family if they confront him, so this Mr. X retrieves his licensed firearm. As the intruder exits the shed with stolen goods and begins to approach the house, Mr. X warns him to stop. The intruder, however, charges towards Mr. X, wielding the crowbar in a threatening manner. Now, believing that the intruder may cause death or grievous harm, Mr. X, in a moment of panic and self-defense, shoots the intruder, causing fatal injuries. In this scenario, Mr. X's action could be examined under Section 103, which permit the voluntary causing of death under the right to private defense of property if the offense is robbery or housebreaking at night. Among others, the incident occurred at night and the intruder's aggressive actions could have led to reasonable apprehension of death or grievous hurt, thereby potentially justifying Mr. X's use of force, lethal force in defense of his property and personal safety. Okay, now let's move on to section 104. So 104 says that when such right extends to causing any harm other than death, so if the offense, the committing of which or the attempting to commit which occasions with exercise of the right of private defense, be theft, mischief, or criminal trespass, not of any of the descriptions enumerated in the last preceding section, that right does not extend to the voluntary causing of death but does extend, subject to the restrictions mentioned in section 99, to the voluntary causing to the wrongdoer of any other okay than death. So now, in a simplified manner, if the crime that leads to you defending yourself is theft, mischief, or criminal trespass that is not extremely serious, as described in the preceding section, then you have the right to defend yourself, but not to the extent of killing the person doing the wrong. However, under the limits set by section 99, you are allowed to cause harm that is less severe than death to the person committing the crime. Now, what does section 105 says? So, commencement and continuance of the right of private defense of property. So, the right of private defense of property commences when a reasonable apprehension of danger to the property commences. The right of private defense of property against theft continues till the offender has effected his retreat with the property of either the assistance of the public authorities is obtained or property has been recovered. So, the right of private defense of property against robbery continues as long as the offender causes or attempts to cause to any person death or hurt or wrongful restraint, or as long as the fear of instant death or instant hurt or of instant personal restraint continues. Okay, so the right of private defense of property. Yeah. Okay, so the right of private defense of property against criminal trespass or mischief continues as offender. I'm sorry, as offender continues in the commission of criminal trespass or mischief. The right to private defense against breaking continues. Okay, as long as the house continues, as long as the house trespass which has been as long as the house trespass. All right, I'm sorry, so I'll begin again. So the right of private defense of property against house breaking by night continues as long as the house trespass which has been begun by such house breaking continues. Okay, so now let's understand it in a simplified version. So it says that by okay, so it talks about defending property. So you can start defending your property if you think it's about to be in danger. Okay, and against theft you can keep defending your property from theft until the thief has escaped with the property, you get help from the police, or you get your property back. Against robbery, so you can defend your property against robbery as long as the robber is threatening to hurt someone, actually hurting someone, or keeping someone against their will. This right lasts as long as the threat or harm is immediate. Against trespass or mischief, you can defend your property from someone illegally entering or damaging it for as long as the person is doing these actions, and you can defend your property from someone breaking into your house at night for as long as the break in is happening. Okay, now let's understand the last section of today, section 106. So right of private defense against deadly assault when there is a risk of harm to a person. If in the exercise of the right of private defense against an assault which reasonably okay all right all right Okay, so this section says that if in the exercise of the right of private defense against an assault which reasonably causes the apprehension of death, the defender be so situated that he cannot effectually exercise that right without risk of harm to an innocent person, then his right of private defense extends to the running of that risk. Let's understand it with the help of an example. Okay, so A is attacked by a mob who attempt to kill him, murder him. He cannot effectually exercise his right of private defense without firing on the mob, and he cannot fire without risk of harming young children who are mingled with the mob. So A commits no offense if by so firing he harms any of the children. Okay, so this is the illustration. Now in a simplified way, so it says that if someone is defending themselves from an attack that makes them fear they could die, and they cannot protect themselves without possibly hurting someone else who is innocent, they are still allowed to defend themselves even if the innocent person might get hurt. So as we saw in this example, even if the young children get hurt, then also it is not an issue. Okay, so alright, that's it. Thank you for your kind attention, and please like, subscribe this channel for future legal updates and such informative lectures. Thank you so much.